I'm Alexis Schewrha with Campus Reform, and you're watching 5 Big Questions. Today I am joined by Teresa Manning. She is the Policy Director at the National Association of Scholars and is the author of the report, Dear Colleague, The Weaponization of Title IX. In June, the Biden administration unveiled its revisions of Title IX, which updated the regulation's language to include sexual orientation, gender identity, and sex characteristics. However, the proposed changes also pose an alleged threat to due process. Teresa joins me now to discuss. Teresa, thank you so much for taking the time.
I'm happy to be here. Thank you, Alexa.
Of course. So Title IX is most commonly known for expanding athletic opportunities for women, especially in athletics and sports. However, your book discusses the impact that the regulation has on due process. Can you talk more about the intermix between due process and Title IX?
Yes, it might help, though, to start with the definition of what Title IX is for listeners. It is the congressional ban on sex discrimination in federally funded education, also known as an equal access law, popular in the 60s and early 70s with the civil rights movement. Feminists were sort of piggybacking on the advances in race relations. The equal access that Title IX guaranteed was for education. And the Supreme Court has ruled on Title IX and has emphasized that the essence of this policy is as a guarantee of equal access to education, which can't be deprived based on sex. So you mentioned sports. That is interesting because it was the early controversy regarding Title IX, even though Title IX itself at the time it was passed wasn't that controversial because it was viewed as a benign equal access law, unlike the Equal Rights Amendment, which was in the news a lot at the same time and was controversial and never succeeded. Title IX was not, but it wasn't anticipated that it would apply to sports, and that constituted the first controversy. And that's important because really what Title IX was originally marketed as is very different from what it has become. Now it applies to sports, then it was applied to sexual misconduct, later to dating customs and conventions, and now a due process brouhaha. In brief, Title IX now is an office on campus where mostly young female students will go to complain regarding dating conduct. And that is viewed as sex discrimination because of the expansion of that term. As I say, first for sports, then for sexual misconduct, now for dating mishaps. And I think the second important thing to realize about Title IX, in addition to what it originally was, is who is running it. These offices, Title IX offices, are overwhelmingly run basically by feminist ideologue types. The report that you mentioned that I authored and was published in 2020 surveyed the personnel at the Title IX office, as well as partner offices on campus that participate in Title IX proceedings, like women's centers, equity offices. Overwhelmingly, the background of this personnel is ideological. That is, they have backgrounds in women's studies or gender violence studies. So these are not impartial arbiters of misunderstandings that would happen in dating. They are ideological and, importantly, not legal. They don't have any practical experience processing complaints, serious complaints now of basically what can constitute a criminal offense. Of the 59 officials surveyed, only one had actual legal experience in court with due process, that is, defending a party against serious accusations. Let's talk about what due process is so the listeners can follow. Due process is the legal term for fundamental fairness in the legal system. That's where it derived and evolved. It's called the basket of rights and is especially important to protect a single individual up against a powerful opponent, such as the government or any institution like a university or college. Due process includes things we've all heard of, such as the presumption of innocence, the right to know the accusation against you in its particulars, the time, the place, particular description, the right to see evidence, including exonerating evidence, the right to confront your accuser, to examine witnesses, and the right to appeal. All of these rights comprise the basket of rights that are called due process or fundamental fairness. Impartial decision makers is also a big part of that basket of rights. So the problem here is that you have in charge of Title IX people who have no experience, no real practical experience at all with fundamental fairness, with due process. They don't have real courtroom experience, and they're exceptionally ideological. They are all cut from a sort of militant feminist cloth. In DC, we often say that personnel is policy, that no matter how good the policy is, it depends on the personnel to give it effect, because the personalities in the personnel are going to determine how a policy actually comes to life. And the problem we have with Title IX is that however benign it is on paper, and however good it seemed to those who supported it at the time it passed, it is now in the hands of feminist ideologues who, again, have no sense of being fundamentally fair with serious accusations. So now any dating mishap can be considered a sex discrimination claim, and the Title IX office on campus can treat it that way, and can historically, and we've had a lot of developments over the past few years, but dating from the Clinton and Obama administrations, those Title IX personnel would hold what are now called kangaroo courts or sham hearings, denying an accused student, typically male, of the presumption of innocence, of the right to see accusations against him, of the right to see exonerating evidence, and impartial decision makers. None of that was supplied. So Title IX over the years is now having major issues with fundamental fairness or due process. And as I say, a lot of activity over the past few years, because those railroaded students have gone to court to sue their schools, to say they were deprived of due process, or to even claim that they, mostly these accused male students, suffered from sex discrimination in violation of Title IX, which is an interesting development. And by and large, courts are finding in favor of those wrongly accused students, those wrongly treated students, and against schools. We now have hundreds of decisions where courts have said to schools, you cannot do this. You cannot brand someone a rapist or a sex offender, all the while denying these due process basics. In addition, under Betsy DeVos in the Trump administration, she promulgated a formal rule to govern these Title IX offices on campus. And that rule put in black and white those basic due process protections. So it was a 3-year effort of weighing the interests of accusing students and accused students. And she came up with a very good workable rule that has been upheld by all the courts that have looked at it. The Biden administration, however, is going to undo the gains of the DeVos rule. But I think the biggest takeaway from the Biden proposal is that it gives more discretion to the ideological staff members on the ground. So, for example, it gives the Title IX staffers the option to have a formal hearing with cross-examination and recordings of what is said, or to have an individual meeting, which is more informal and run entirely by the Title IX staff. As a practical matter, it's going to be easier for the Title IX staff to avoid a formal recorded hearing and hold instead an individual meeting. But that leaves everything in the hands of people who have no practical legal experience with due process. So that very discretion, that very option is already a massive threat to the due process guarantees that the DeVos rule secured. So I'll stop there, hopefully providing context so you and your listeners can process what the Biden proposal is upending, and you can ask questions or I can continue. Just let me know.
Absolutely. And I'm glad you gave us that complete overview because it does prompt me to ask this follow-up question. What is the justification that the Biden administration is providing to be doing these immense changes to Title IX?
None. They have not provided any justification whatsoever. And one of the immediate comments that I made was how wasteful this effort was, because the DeVos rule had just been completed, that is less than 2 years previously. And I'm sorry, less than 2 years previously, and the effort had taken 3 years to achieve. So this is grossly wasteful, very duplicative of efforts already made by federal officials in the Trump administration. They have offered no justification, although on the face of the proposal, it's clear what they are doing. In addition to Title IX being expanded so that it addressed sports and then sexual misconduct and now dating, the federal bureaucrats continue to tinker with definitions to expand its reach. Mind you, the courts have not been on board with this. This is all the federal bureaucrats in Washington, D.C., and their allies on the ground on college campuses. So now they have in the past and continue now to expand the definition of what constitutes sex discrimination. Some of your listeners may be familiar with a quid pro quo proposition in education, where, for example, a professor would demand sex in exchange for a high grade. You have that in the employment context as well, demanding sex for a job or a promotion. That is not controversial, meaning everyone agrees that that does constitute sex discrimination. But there's another form, much more amorphous and hard to define, which is what's called a hostile environment type sex discrimination. And there, the bureaucrats have had a heyday in toying with that definition. In the Clinton and Obama years, it was unwelcome sex misconduct perceived subjectively, which obviously is problematic, because what is viewed as innocuous by one person can be viewed as pernicious by another. A subjective standard is almost the definition of lawlessness. You can't have things being against the law just depending on what one person thinks. So holding a door open for someone might be a courtesy for people, but for a militant feminist, it might be unwelcome sexual misconduct. That's how silly such a standard can be. So they have toyed with this hostile environment definition, and now they are redefining sexual harassment, as you mentioned in your introduction, to redefine sex so that it includes gender identity and sexual orientation. And the meaning of this, again, is anybody's guess. If one has objections to gender identity or doesn't go along with the pronoun demands that are made, this can now be considered sex discrimination under Title IX. This is all hugely problematic because under our Constitution, legislators are the ones who make policy. And at the federal level, that means Congress. policy cannot be made by unelected, unaccountable federal bureaucrats. And yet, that's precisely what they are doing. So this is a power grab by pathological federal bureaucrats who want to impose left-wing policy through executive agencies with no democratic accountability whatsoever. I think a showdown is coming between the courts and the Biden administration. The Supreme Court, just within the past month, issued an opinion reining in the Environmental Protection Agency on precisely these grounds, that the EPA cannot make policy decisions by redefining terms or coming up with plans. That falls to the United States Congress. And I think the Biden Education Department Office for Civil Rights is engaging in the same administrative overreach by redefining sex in a way that Congress never intended in 1972 when it passed Title IX, and redefining it in ways that most Americans don't accept. So this is administrative overreach at its worst. And I don't think they're going to get away with it, since the courts so recently have just addressed precisely this point.
Right. And to shift the conversation more towards the college students, what do you think that students need to know going into this fall semester about their rights protected under Title IX?
Yes, it is a little bit uncertain. Right now, the DeVos rule, which does guarantee due process protections, remains in effect while the Biden people go through the steps to promulgate their new proposal. It's a very tough question because I did visit 5 campuses in Virginia and New York State, and really the Title IX office is almost starting fires that it then wants to extinguish with its kangaroo courts. So the Title IX office has become a place where graphic sex brochures are distributed, condoms are distributed, multicolored condoms. They're encouraging what are called hookups. I'm sure you've heard about the hookup culture. At Virginia Tech, they actually hire a contractor to talk to students about how great hookups are, sexual hookups. Well, this is the type of climate where misunderstandings are almost guaranteed. Alcohol is also a huge problem in socializing and college partying, and again, inviting misunderstandings. And these school officials are creating these fires. They're starting these fires, promoting sex on demand and hookups, not doing anything about alcohol consumption. And then the day after, when someone feels that she was wronged or there was a misunderstanding, they are encouraged to march to the Title IX office and complain. So I don't know how to advise students other than to be aware that this apparatus is ready to pounce. And I would avoid that type of socializing, because one could call it a trap. You know, they're seducing students into a sex on demand culture, and then the Title IX office stands ready to pounce and prosecute and railroad students who are accused. I should mention there is a conflict of interest here, that the Title IX office only justifies its existence, and these staff members only justify their jobs if they get complaints and if they have their busy work of processing these complaints. This is a standard conflict of interest where someone's job or income depends on having wrongdoing on campus. So this is a trap for a lot of students, and I would say female students as well as male students, because everyone loses under these conditions, with alcohol and a rampant promiscuity and sex on demand, it invites misunderstanding, it invites pain, and a Title IX adjudication is no answer to that. Title IX really should be helping students navigate their access to education free of discrimination and not adding fuel to this fire of the hookup culture on campus.
Absolutely. And in your research on Title IX, do you find that more Americans would support the Biden administration's changes, or would more Americans oppose it?
I think Americans definitely would oppose what the Biden administration is doing. After all, Americans have the United States Congress as its representation for federal policy. If Congress wanted sex to be redefined in this federal law to include sexual orientation or gender identity, Congress could do that. But Congress has not done that. And so these are federal bureaucrats going behind, sneaking behind the democratic process to impose left-wing policies that they could not achieve through the democratic channels. So the very fact that they're using bureaucrats and not legislators is almost evidence that they know the American public is not in support of this. And indeed, we are seeing major pushback against the Biden proposal for all these reasons, for the threat to due process, for the redefinition lawlessness of the term sex. For all these reasons, citizens and organizations are pushing back. And your listeners should know that there is right now a public comment period that ends on September 12th. You just have to go to the Federal Register to look at the regulation. In the upper right-hand corner is the green button where you can comment. And we are encouraging all American citizens to comment to oppose the Biden proposal because of its attack on due process and attack on the democratic process as well.
Absolutely. And how long do people have to file those public comments? And what else can they do if they really want to step up and take action?
Yes. So September 12th is the deadline for making a public comment. And there's strength in numbers. So for people concerned about due process or administrative overreach by these federal agencies drunk with their own power and engaging in this type of lawlessness, it's best to join an organization that can be a voice in DC or elsewhere, depending where the fight is. So consider joining the National Association of Scholars or other groups that have been advocating on behalf of due process. There are many out there. A quick online search will unearth all the different organizations, but the National Association of Scholars is a very powerful voice in favor of due process, so listeners should consider that.
Absolutely. Great information. Teresa, thank you so much for joining me today.
Alexa, thank you very much.